Meeting to order tonight, and let's just, for the benefit of all our in-person audience and our viewers virtually, we'll go around the table and identify ourselves. I'm Eric Rockwell, the commission member from the 3rd District and chairman.
My name's Edward Kramer with the 7th District.
John Delaney from the 5th District.
Adam Phillips, council staff.
Tom Bostwick, also council staff.
Kareem Creighton with the Brennan Center for Justice.
Welcome, Dr. Creighton. Thank you for giving us this talk this evening. And I'd note that virtually we have Cordell Grant and Michelle Davis, who are commission members.
Hi, yes. Hi, this is Cordell Grant, representing the 4th District.
Michelle Davis, District 1.
Thank you both. All right, the first matter of business is approval of the minutes from the March 6th meeting.
I make a motion to accept the meetings, the minutes as read. Well, not read, written. Excuse me.
Do I hear a second?
I'll second the motion.
All right. All in favor? Aye.
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 All right, next is a presentation from Dr. Kareem Creighton, who holds both a JD and a PhD, and he is the Vice President of the Washington office of the Brennan Center for Justice. And again, Dr. Creighton, we thank you for taking time to inform us today. So I'll turn the floor over to you.
Mr. Chairman, if I can, I just want to say one thing. Just to kind of give some context and background, I can't emphasize enough for you all and anyone who's in the audience how privileged we are to have Dr. Creighton here. When Adam and I were, trying to develop a program for this redistricting process, we obviously put together a redistricting manual for you all and the public, which we think is very good, but, and we also felt that we were pretty well versed in redistricting, having gone through this just 3 or 4 years ago. However, we were certainly not subject matter experts, and so we wanted to bring in someone from the outside, so to speak, to not only educate you all, but also to educate us a little more on the Voting Rights Act and some of the legal parameters and pitfalls that go with redistricting. So we connected with the Brennan Center for Justice out of NYU Law School. We then specifically connected with Dr. Creighton and his staff, and it's been great getting to know him for the last month, and kind of going back and forth on some things that we could do for this evening. And so again, I just want to say that I'm very gratified that Dr. Creighton took the time out of his busy schedule to come here this evening to basically make this presentation for you all and again for the public. I think it's very beneficial to everybody. So thank you very much. Now. I hope I didn't overdo it.
I just, you have not gone past my mother standard, which is good. I'm not thoroughly embarrassed, but I'm appreciative of the introduction and the very warm welcome, Mr. Chairman. Thank you all for the opportunity to speak with you. As Thomas mentioned, I have done about everything there is to do in redistricting. I've worked in jurisdictions across the country, and I've done it in a lot of different settings. I would say, frankly, redistricting that is closer to home and involves citizens are the most fun versions of that. It's serious business, but I think it is often an opportunity to learn publicly about an important function of government. So that's how I look at it, and I hope as we talk this evening that you'll see some of why this is, I think, an opportunity that I think at the end of it you can walk away being happy about, if not ecstatically happy, happy about. What I thought I would do is really talk about 20 minutes or so. I have about that much in terms of remarks, but I understand that, you know, you all have probably any number of experiences or questions that you might have. I'm perfectly comfortable being, you know, stopped at some point if something's not clear or you want to ask a question or two. I'm happy to do that. I would just offer a couple of things just as sort of my entry point so you know kind of what I'm bringing to the table. I am obviously a person who's got a lot of experience in redistricting. I'm representing here the Brennan Center, which is a nonpartisan advisory organization that develops both research, advocacy work in terms of reports, but also it's a communications hub, and our commitment is defending democracy in all of its forms so that more people can have access to political power and the ability to be represented in government. So those are my priors. I come at this process really as a person to talk broadly about the law that applies in redistricting. So I don't mean to offer any particular opinion about, you know, this process. We can talk about it, but I want to just let you all know that my goal is in this conversation to really give you a landscape representation of what, you know, can sometimes be a little bit complex area of the law, but that really at its elemental stage is pretty straightforward, even if the choices can be complex. So with all of that, I want to advance to the first slide to offer you what I would say is sort of the playbook on redistricting. No matter where you are, no matter what, you know, how many lines you're drawing, redistricting comes down to a few key things in the law that you need to keep aware of. So if we go to the first slide, we can see, oh, there we go. Yeah, the playbook that really outlines the key elements of every redistricting. The first thing that we always do when we draw maps is to assure that districts are equally populated. I'll talk a little bit about the why, but generally it flows from the notion that when we cast a ballot, the casting of that ballot has roughly the same power as someone else who lives in another district or perhaps your same district. You should have, as an equally entitled citizen of the country, the ability to affect power just as everybody else can, right? So equal districts are sort of one key bedrock function that we always have to attend to in redistricting. The second element, and I confess that my eyes are failing me, so I'm going to try my best to remember, thank you so much, all of the elements that we have listed, but the second element relates to race discrimination. We have in our country a history that we've inherited that shows for a long period of time we've fenced people out of the political process based on their race. And so we have a series of laws that attend to respond to that concern so that we don't do that again. So this idea that when we draw districts, we don't what we call dilute artificially the votes of an identifiable community is another key feature of the rules. We call these usually protected classes that includes groups like African Americans, Latinos, Asian Americans, usually so-called language minorities, but essentially we're not artificially over-concentrating people or dispersing people that would interfere with their ability to cast a ballot and to choose candidates of their preferred option. While we also think about the concern about discriminating against voters by over-concentrating or dispersing them, we're also given direction from the court that we don't take race above all other factors in drawing maps. So consider race so that we're not discriminating, but don't consider race so much that it overwhelms other traditional features of the redistricting process. And I'll talk a bit about those later. So those are sort of the three kind of bedrock directives we're given in sort of federal law about it. There's also a fourth principle that has emerged. I was telling Thomas I was unfortunately steering the ship. I shouldn't say unfortunately. Fortunately, steering the ship on one of the big fights about partisan gerrymandering. We did not succeed at the Supreme Court of the United States, which told us, and this gets to the fourth principle, that partisanship is a permissible consideration when we draw districts. Now, actually, the state of Maryland was one of the cases, not the one that we were involved with, but a companion case that was taken to the Supreme Court. The court said, essentially, as far as federal law, the Constitution are concerned, we don't have anything in the 14th Amendment, says the court, to help us decide when partisanship is too heavily informing district drawing, so therefore we're not going to police it at all. So the court's taken no official position on whether you like it or not. They're taking the position that the federal Constitution doesn't prohibit it. So if states choose to do so, they can. However, of course, states have chosen, some of them, not to do so. Maryland's now Supreme Court, at least in a recent case, has put a limit on the way in which the legislature here could use district drawing to use partisanship in drawing congressional districts. Open question what that means as far as local districts are concerned, but as far as the state constitution is concerned, Maryland and some other states have put a limit on that. So partisanship is okay as a feature to be aware of in drawing districts, whether the Ds or the Rs have more people in a district or not, but there are some limits under state law that might put a sort of cap on how much you could consider it. But it's not forbidden to take care of that information, to take that information into account when you draw maps. So I want to delve a little bit more into each of these sort of directives, and we can maybe open the floor if there are any questions about it. We'll just go first to the point about equally populated districts. You've probably heard the phrase one person, one vote. That's sort of the concept that kind of drives this idea. And in fact, the organization that, oh yes, the next slide, perfect. The organization that I represent, the Brennan Center, is named for William Brennan, and one of his key opinions that he wrote was about the case that gave rise to this notion, Baker versus Carr. And the one person, one vote principle I've already talked about. You as a person casting a ballot should have, under our federal constitution, roughly equal power to affect political outcomes as everybody else, right? And what it says in principle is we can't have districts that are so heavily populated in one district but lightly populated in another, where the votes cast by the ones that are in very few, where there are very few people in a district, have more of a chance to affect change than, say, the ones that are overly populated. And the question really in this mode of thinking is, how equal does equal need to be? Because obviously people don't live in perfectly divisible communities and all. So the court has come up with some subsidiary rules to say how equal needs to be. At the federal level, generally, the standard is you got to get as close to zero as you can, like mathematically zero. So what would you do? You'd look at the number of districts, number of people in a jurisdiction. You know, in Baltimore County, it's about 850,000 people. You divide that by the number of available districts, and essentially those numbers need to be as close to equal as possible. We have a measure called deviation, which is basically the, number of people that you're off from perfect mathematical equality. And that's usually our measure for how equal your district map is. Generally speaking, at the congressional level, if you're off even a little bit, you need to explain why you're off, and it better be a good explanation, because again, the standard is zero. The closer you get to home, right, that is counties and cities, there's a little bit more give that's permitted as far as federal law is concerned. And the reason is jurisdictions differ, right? A city might be different from a county. One county, Baltimore County, will be quite different from Howard County for all sorts of reasons. And so what the court recognizes is that when you are drawing these districts, things like where rivers run, or if there are communities that exist, that might require you to take account of those differences in a way that maybe at the congressional level, where you're going to cross all of these, large numbers of communities, that's going to be a little less relevant. So what it says is there's a little bit more deviation when you're dealing with counties and cities when you draw district maps than at the congressional level. Now, again, just as I talked about with partisan gerrymandering, Jurisdictions can adopt their own limits beyond what the federal government does or doesn't permit. And generally speaking, I think Baltimore County has roughly that limit where even though the Supreme Court hasn't officially ruled on it, the Supreme Court has said when you're in local jurisdictions, as long as you're within roughly a 10% level of deviation, that's usually 5% above or below what perfect equality is, you're generally okay. So again, allowing for a little bit more variation based on the particular circumstances of a jurisdiction or perhaps the traditions of how districts are drawn. While we're here, I want to talk a little bit about traditional principles because this often gets thrown around in, court opinions, and people talk about it in policy conversations, and we're never really precise about what that means, in part because the truth is there's no precise list that anybody put on a tablet to say these are all your traditional principles. But the ones that get mentioned most commonly are things like contiguity, that districts have to be one whole, where you have to be able to draw the district without lifting a pencil. It's a whole shape, not separated. That they have to be compact. Again, some places create a law that says there's a measure from compactness and you have to abide by it within range. Compactness scores and measures will differ. Political science is replete with different ways of judging it, but essentially compactness is a notion that it looked more or less like a shape you learned in kindergarten, right? The more abstract and peculiar the shape, usually the less compact that is. There may be reasons for it, but that's usually the traditional norm. Now, some jurisdictions will adopt norms like we follow rivers, or we respect local jurisdictions like cities or villages or neighborhoods. Some will think about, now this is where it gets a little iffy, but I again throw it out as one of the things that people look at, and it goes a little bit into partisanship, but not necessarily in a partisan way. They think about incumbency. So some jurisdictions will say, look, we have redistricting, we don't want, for example, incumbents fighting each other over turf, so we're not going to unnecessarily put two incumbents in the same district unless we have a good reason. So it tries to, forestall turf fights where I don't like you, Senator A, so I'm going to make sure that you are in a district that you can't win. That sometimes comes up, but there's some traditional principles that sometimes a jurisdiction might adopt to avoid that kind of fighting. Or some people will say, and this is a really loosey-goosey standard, but I'll just offer it as one time, sometimes people will throw this in, that we'll try to preserve the core of existing districts, which, obviously because you have to equalize populations, that might change, but if one says, look, we don't want to shift a district more than a certain percentage, recognizing that people like contiguity, that can be a choice. Again, none of this is set in stone. These are just some things sometimes that come up in the mix. So that's the story on equally populated districts. Just make sure that they're roughly equal. If they're not equal, you might see an argument for maybe we should explain why they're not equal. If we're going to sort of say we're okay with a little bit of deviation, if we're pursuing another consideration that we think is important as a group, I say we, I mean you, then that's okay. If everybody agrees this is an important reason to have a district that reflects, again, communities that tend to see themselves as a unit that should be kept together. So that's all I need to say about that now. I would like to go on to the next slide, which talks about the second standard, which is vote dilution. I've already talked about the history that gives rise to these laws. The key law in question is the Voting Rights Act. There are a few laws, but that's the most important one that tries to assure that when we engage in election changes like redistricting, we don't do it in a way that unduly burdens an identifiable protected class. And the standard there that we focus on is assuring that the group in question doesn't have less of an opportunity than others to exercise their opportunity or their choice, their preferred choice of candidate. They have to be given an equal opportunity to cast a ballot for the candidate of their choice. Where systemically we created a system where they are less likely to have the equal opportunity to effect change, that triggers some inquiry under Section 2 of the Voting Rights Act. I'll talk a little bit about what that means in practice. As I said earlier, earlier, the general notion is you don't want to over-concentrate or overly disperse identifiable populations that could, if grouped differently, be able to elect a candidate of their preference. So the law is quite complex. I'm going to synthesize a lot, but essentially when a group thinks that the jurisdiction has done a poor job of that, either by over-concentrating or overly dispersing a class, they go to court and the court asks a series of questions. And it comes from this case called Thornburg versus Jingles. It comes to us from North Carolina in 1986. And essentially the court constructed a sort of prima facie test, a checklist to say when it's likely that the district map has offended Section 2. And I've listed the three general questions. The first one is, does the group that says that they've been wronged by the district map have the numbers to actually direct the outcome in a district? Put really bluntly, could they be a majority in a district differently constructed than the one that the district or the jurisdiction has drawn? If they're geographically large and compact, that's sort of the language, then the court goes on to the second inquiry, right? That is, you could draw a district with this group of people, but then it asks the second question, which is, all right, are they a politically cohesive group? Which is to say, all right, we know that they identify, you might have a group that shows up and says, look, we're a community, but then the question is, are they a politically salient community? Do they see their common interests and do they express them typically in elections in the same kind of way? Because the question really is about the remedy. If we draw this group in a district, are we seeing them behave in a way that shows that they are a community, such that their expression of their interests would likely elect a candidate that they would prefer? Now, that gets a little complex when we deal with certain language minorities, because often language isn't necessarily viewed the same as race for every group. Groups, for example, if you're Asian American as a category is a thing in the census, but of course that defines ethnic groups from a large part of the world, right? And so one uses part 2 of this analysis to ask, all right, we know that you say that you're a part of a group. We want to test out how you have behaved in political contests as a group, and frankly, even outside of politics. Are there things that you share that sort of show that you are a cohesive community and not just sort of on paper groups that fall into a particular category? And the third is really crucial. As I said, number 2 gets some to thinking about the behavior of a group in political contests. But the third is to ask a different question, which is, in the system as it's currently constructed, are we seeing elections play out in a way that this group that's claiming that they need access to a different district map and they're entitled to it under law, is that group consistently outvoted by the majority in the jurisdiction such that they consistently are losing elections? So just to take the quintessential case, when African Americans are, 25% of a jurisdiction, and they're not drawn in a space, let's say they're 4 districts, and they're geographically concentrated, they might be able to, be a majority in one district. If it's shown that and this is the easiest case, in elections where there are no districts and they vote at large, the 25% always votes differently from the 75%, such that they are always going to lose. That's some evidence, if it's consistent over a series of elections, that there's what we call racially polarized voting. And that's a complex analysis, but essentially it means if you have if you can predict for the next 5 or 10 elections, based on the last 5 or 10 elections that you've seen, that the division is always that, no matter who the candidates are. It may be maybe 2 white candidates running against each other, but if they always fall along the 25% voting one way that are African American, and 75% or close to it of white voters, that's usually a quintessentially divided or a block voting situation where you would want to have some intervention. Now, I've said 3 factors. Those are 3 factors that the court looks at to determine whether or not more inquiry is needed. So if you can check those 3 off, you're in a pretty good spot if you're a plaintiff. But then the court asks.
I do.
Yeah, go ahead.
Hey, Alabama, a couple years ago,
Yep.
didn't he just have a case and basically, okay, just wanted to make sure that I was understanding
Yeah, Alabama
correctly.
had this case. In fact, I will tell you, in another world, I was, yes, I advised many of the people in the legislature who were trying to get the districts that ultimately were drawn. And right, that is a quintessential case of polarized voting. And we showed all the evidence, and unfortunately the legislature didn't listen, and $1 million or so later, they had to do the thing that we were asking them to do. But that's right, when you have a prolonged state of division that tracks race, then it's an instance where a court is likely to find that there's racially polarized voting, and it goes to this next inquiry, which is taking all of this into account. Do we think that it is helpful and appropriate to adopt a remedy? It's a totality of circumstances test, and it's an extra check just to make sure, yes, you've checked all of these boxes, but the district court judge usually is asked, well, does it make sense here? Does a remedy make sense? And if you pass all those hurdles, the court can sometimes say, yes, I think there's a remedy that's needed. Either I'll invoke a remedy or I'll direct you to choose a remedy if you're the jurisdiction. Now, I've given you the story on one side of the street, which is if you've got evidence of discrimination and racially polarized voting, you should, in all instances, even if you're not sure about it, you should make sure that you're drawing districts in a way that won't discriminate. On the other side of that, as I said earlier, you can't do it too much, says the Supreme Court. So essentially, those traditional principles I described earlier are what the court would say normally every district drawing body will need to take into account. The only thing that the court really says is, look, keep those in mind, and keep in mind the concerns about discrimination. Just don't let the topic of race on its own overwhelm everything else. And essentially, the key case on that is Shaw versus Reno. There are a few other cases, but essentially what the court says is this. If you don't know anything else and you're just starting to draw districts, it's not the wisest move to start from a proposition of you have to draw X amount of districts and this district has to be the district for Black people. That's really the key part of the analysis that the court has sort of triggered in the past, this notion that the 14th Amendment bars districts being drawn that way. If a district is so irregular in shape, for example, that the only way that the district can be explained is we drew this to take in Black people or whatever the racial group is in question, that's usually a sign that you've offended the 14th Amendment. It gets more complex than that, but the main point to see here is take race into account. That's not forbidden, but don't let it override other considerations that you've thrown into the mix about how you want to draw districts. If it is, the one exception generally, if you are ordered by the court to take account of, drawing a map as in Alabama. You've rightly raised a great example. Alabama had offended the Voting Rights Act, Section 2, by not drawing a second majority Black district that by all accounts, really, it could not have been an easier case under this analysis that I just offered you. They didn't do that. So the district court said, all right, you've offended Section 2. I'm ordering you to draw a second district that reflects political opportunity for African Americans, and it looks, in our view, like you should draw a majority Black district or something close to it. Those are essentially the words of the district court. Now, when that happens, you have to take that into account. But barring that, you should always think about this complying with federal law amidst the other considerations that are part of the traditional mix of considerations that you draw districts with. Complying with federal law is an important and, in fact, often preeminent of consideration, which is the same as drawing equally populated districts. But just as to take this example further, if you choose not to draw, if you go beyond 10% and deviating districts, one district from another, and the reason you did it was, well, I wanted to draw a majority Black district, without more, I would have a lot of questions about complying under the 14th Amendment. So again, you can steer a nice path, I think, through these considerations for reasons that really go to setting out what your standards are about how you're going to draw before you actually draw. That's one bit of advice I'll offer in general. But I would just be cautious about thinking about how to, on one hand, avoid concerns about discrimination, but not letting that conversation overwhelm every other consideration that you would take into account in drawing a map. We can talk a little bit more about that as needed, but I think that's all I want to say about that, and get to actually just to show you a map that you will all be familiar with, the map of the county. This is just an illustration of how one might think about drawing a map. Oh, I'm sorry, I missed the question. Thank you.
Yes. Doctor, have the courts drilled down any with regard to the notion of geographical compactness to set standards in that regard?
So the court has endorsed respect for geographic boundaries as one of the traditional considerations in drawing maps. There's no specific measure for that the court has embraced. In part, it's sort of recognizing that, look, you know, we're lawyers and judges. We don't do the work of political scientists who themselves don't all agree about what the best way of measuring geographic, whether you call it, you know, respect for geographic lines or continuity, that can vary. And it is in some ways a policy decision that the jurisdiction drawing needs to take. But I would also offer another bit of advice, which is you're always helped by getting public input. So being guided by, in part, what people tell you are relevant communities and geographies that should be respected can be a good way of getting on the record thoughts that you might reflect in districts. So yeah, that's one consideration. But going to this map, this is just sort of a way of helping you see some of the, you know, complexities of drawing a map. And this just shows you the distribution of African Americans by block in Baltimore County. And again, this is stuff I'm sure you already know. There's concentrations on the west side of the county, southwest side of the county, and the southeast side of the county. Just to illustrate the point, I would, you know, if you were to, just knowing nothing else about this, if you were to draw a district that tried to bridge all the people in the west, in the heavily African-American concentrated parts of the county with all of the areas in the east, southeast parts, you would probably raise some questions about, you know, whether or not that district is defined by race. Now, it's not to say that you might not draw a district that kind of bridges two different parts of the county. It's just to say you'd have to take into account all the different factors that you would have in drawing your district map as you're thinking about assuring that you're not overly concentrating or overly dispersing any particular racial group. In this case, I'm speaking about African Americans. So there are a lot of different ways to do it, but this would be an appropriate piece of information. I'm showing it because I am complying with law. This would be one of the things you'd want to think about as you're drawing a map, because again, you'd want to know where people are so that as you're drawing, you're not unintentionally or intentionally drawing a district that might artificially concentrate or disperse a particular group that might have an entitlement to respect under the Voting Rights Act. So I think we can move on to the very last slide, I think it is, which is partisan gerrymandering. And again, I don't actually need to say all that much here other than to reiterate the fact that much like race, unless you have a bar against it in your local jurisdiction, awareness of partisan trends is useful. It's useful, by the way, sometimes in thinking about racial discrimination, because when we talked about it earlier, the third part of the Jingles test is all about thinking about past elections to see whether or not outcomes unduly place a plaintiff's class, in this case, I was talking about African Americans, in the loser's seat. If you're always losing because of political division that tracks race, then you need to be thinking about whether or not you've offended Section 2. Well, one way of doing that is to look at past election results, which may be partisan, all right? And that doesn't mean that you're, you know, overwhelmingly thinking about D's and R's. It means sometimes you're doing it in the context of understanding how a particular class of citizens vote. But even as, you know, we talked about it, there are no particular bars at thinking about this from the perspective of D's and R's. I'm speaking as a nonpartisan here, but you know, aren't barred from doing that. Now, you'd have to, you know, maybe think about how that looks in the context of all the other considerations you're taking. But it is just to say here that, you know, states do have some limit on that. And I would generally say, as I would anywhere, you never want to be the person that tests a limit, but one can, but this is the place where just remind you, the state Supreme Court here has put a bar on congressional redistricting and the overuse of partisanship. Hasn't done that in, local jurisdictions, but it is fair to say in all of them, there's no bar against being aware of partisan results in the past or being, thinking about like, some jurisdictions do. This is another choice. I'm not saying you should make it. There, people who say, well, we want to be guided by what the results are in the county overall. And if the county, is voting whatever, 60-30 or 50-50, we want districts that kind of reflect that too. That may be how you think about it. It may not be. But those are different ways in which partisanship might inform how you draw maps. So I think that's all I need to say about the basics. I just end by offering, the points again that I offer in all conversations about redistricting. I'm really at my most comfortable because A, there's a PowerPoint, and B, there's maps. I live in this space. Thank you, Adam. But generally, what I would say is one thing that everybody should do, and I think you all are doing it, is really to involve citizens in the process. The fact that you all are, in the first instance, drawing a map that, will be under consideration is a good thing. Taking public input is also a good and useful thing. I would also just offer, general sense, it's always good to be clear about your priors. I tried to do that in this conversation. I would say, as you're thinking about drawing districts, these aren't easy things to do, but having a sense of what you want to accomplish, like what are the factors that you think are important as a group, that might be something you get input about as well. But having those clear in mind, whether or not you prioritize them, helps set a language that you all can use as you're drawing district maps, because, you could sit today and draw the maps, but not knowing kind of what the consequences are or why you're drawing the maps, I think is, opens up a lot more opportunity to be farther behind in trying to get to a consensus about what the answer is. And I guess that's the last thing I'll talk about, which is, one good thing about starting with priorities and also obviously being directed in part by public input as well as data is that when you come to a conclusion, you can explain it. One of the things I always try to encourage people that I, even in informal conversations like this, I try to do is to say, look, if you're ever concerned about whether or not people are happy with it or mad enough to go to court, always feel free first to sit down and figure out whether or not you can explain to each other why you did a thing. Because if you can't explain it, your lawyers won't necessarily be able to explain it, but it'll be a harder thing to explain, if ever, and who knows, again, make no pronouncement about what this situation is, but you want to be able to easily explain why you did what you did and why it was consistent with the law to a court. That should, in my mind, I think it is always a good thing to have in your mind, because you can't control what other people choose to do, but what you can control is the record that you build and what your reasons are for the choices that you make. And to wrap up, I'll just say, these are, I think, always exciting things to do. The standard is not to be, as I say, at Walt Disney World, where the standard is being ecstatically happy. This is a group project where we're involving the public in the group. And so balancing these choices are always complex, and you aren't going to be able to satisfy everybody. What you can do, and I think you should do, I'd encourage you to think about, is explain your choices. And when you can, I think people, even if they didn't get everything that they had hoped, can feel as though they were heard and that there's an explanation for why they didn't get what they wanted. And maybe they'd be motivated the next time to, look at changed circumstances and do it again. So that's really the whole of what I'd offer right now, but I'm happy to answer questions about this or anything else as we go forward. Hopefully I didn't bore everybody to death.
Mr. Chairman, excuse me, Michelle Davis, District 1. I have a question for Dr. Clayton, if it's okay to ask at this time.
Go right ahead.
Thank you. Dr. Creighton, thank you so much for that very insightful share and presentation. I heard you mention a little bit earlier on that there have been scenarios or situations where a community and or a district was not quite equal, I guess, in terms of the count, the numbers, the heads, the residents, or whatever. Do you have any insight on maybe an example that you can cite of why the community or district did not come out equal?
Sure, sure. So this is a question about just population equality. And, you know, as I said earlier, there may be any number of reasons why, you know, the districts aren't perfectly equal. And that on its own, at least at the local level, is not a vice. What you might find, for example, if a jurisdiction says, okay, we're going to draw a map. We're going to draw a map to assure that neighborhoods aren't divided. Right? And it could be that in keeping neighborhoods whole, it's just a, you know, there's no particular value judgment on it, it's a choice. We will end up having a neighborhood that, you know, is so large that maybe it tips the district that it's in up, let's say, I don't know, 3 percentage points more than the neighboring districts, right? Now, two things could be true. There could be another district that is exactly 3 percentage points below exactly where perfect equality would be, at which point your district map as a whole actually has 0 deviation, right? Because the plus outweighs the minus, and as the sort of measures go of deviation, nobody winks at that. But there might be instances where overall there's, say, a 3 percentage deviation net. And you might say, well, the reason is, the reason we did this is we as a group have decided neighborhoods are an important thing that we want to consider in drawing a map. And in furtherance of that, we're going to keep, you know, this neighborhood whole, and the cost of that is 3 percentage points deviation. Now, you surely will keep the neighborhood happy, but also, as far as the law is concerned, knowing nothing else about the scenario we just offered, the law winks at that. It actually says, well, we contemplated that. We actually have a standard that gives you, the local jurisdiction, the ability to take account of things that you think are important, so long as they don't go wildly afield of where sort of like, again, the 10 percentage point is sort of the rough guide that sort of is in the zone of what's reasonable. So it is, you know, that might be one example. I mean, I can think of, you know, there are any number of others, but again, this goes from the notion of, I think you're in a better position to defend that if you ever have a question about it. If at the outset you've said, hey, we've decided, you know, neighborhoods are important, so when we draw maps, we're gonna keep neighborhoods whole. Sometimes you can, sometimes you can't, but maybe it's such an important neighborhood. You've gotten tons of testimony about neighborhood X. We've been divided for years. We really want not to do that. Could you please, you know, you could decide, all right, well, this is the moment where we'll keep this neighborhood whole. And, you know, as it, you know, turns out, costs you a little bit on deviation. Not something to be, you know, overly concerned about knowing nothing else.
Okay,
Was
understood.
that helpful?
Yes, thank you. Thank you so much for the input. I appreciate it.
And I know on some of the testimony and emails we've gotten from specifically concerning neighborhoods, concerns about, you know, like one side of the street is one district, the other side. So I guess that comes into play with that too, with that deviation.
Yeah, absolutely. And, you know, as I said, right, I mean, that goes to, and you can think about all the good reasons why you might want a neighborhood in the same district, right? If you're thinking about how to deal with shared concerns of that neighborhood, it's a lot easier to go to one person to fix it or hold that person accountable if they don't than trying to, you know, get half of your neighborhood to, you know, talk to person A, but half talks to person B, but maybe the budget isn't big enough to, you know, have two different actors looking at it. There, you know, we can spin up a theory, and I don't mean it in a negative sense, to you know, support that, but I think it's a question of whether or not you all, you know, would choose to rank it. But if it is a thing that is important, you can certainly you know, pursue that. You know, the one pause I'd just offer, you know, it is rare to find any principle that you state that you can follow 100% of the time, and I just offer you that's okay, unless there's a law that says you have to do it 100% of the time. Balance is, you know, a part of this. And so, you know, if you think of the illustration of the puzzle, if you're working a jigsaw puzzle, there may be an instance where a puzzle piece doesn't go all the way in. And that's not always a horrible thing. If on the whole, what you can say is you've made, your best faith effort to try to kind of comply with all the different aspects of what you think are important. So just know that it's a complex thing. Not everything is going to be perfectly followed all the time. But, at least where there's not a law that directs you to do so, you can feel comfortable that, that's okay in the whole of things, as long as you all can agree to it.
Have the court set any standards as far as granularity of what constitutes a neighborhood? In other words, have they said that a school district might or might not count, a community association boundary might or might not count, a zip code might or might not count?
Very good question. I am sorry to tell you there isn't that much direction that you get from the court. But actually that I think I want to offer you, that's good news for you all. You get to be, the arbiters of how that should be carried out in this jurisdiction. And again, you can imagine, right? I mean, even, one county next to another, school districts might be the most relevant sort of community of interest is what we call it. But let's say just south in Howard County, it might just be, I don't know, water zones. I'm making this up. I don't know if we have water zones, but, or neighborhoods as such might be it. Because, we don't have cities in Howard County except for Columbia. So I think as you're taking in evidence and thinking through the experiences that all of you bring to the table about what is relevant, I think that's sort of what you get the opportunity to kind of inform. Sure. Mm-hmm.
I actually had a question. At one point you mentioned the idea of not just where a particular class population live, but cultural institutions. Mm-hmm. And in Baltimore County in particular, there is there's a large group of Orthodox Jewish population that, there are very important cultural institutions. But I was kind of wondering if, beyond that one example, if you could give us something else that might count towards that.
Sure. And thank you for the question. Going back to, it's relevant in a couple of ways, right? That is, communities of interest might be one of the traditional considerations you want to take into account. And they can be defined by anything like people who go to the same school, people who attend the same place of worship, cultural spaces. I, was involved with Los Angeles redistricting, and, there are like easily 60 or more different ethnic groups that have representation in the city. And so, people have community centers that become, kind of focal points of the jurisdiction. It's also relevant to an analysis under Section 2 of the Jingles test, thinking about race discrimination, and defining whether a group is politically cohesive, right? Whether or not the group actually sees itself as, outside of politics even, a socially cohesive unit. You don't have to agree on everything, but they see whether, for example, they go to the same places of worship, maybe they're members of the same parish, or maybe they, happen to celebrate a particular ethnic holiday at a particular place. It does need to have some geographic dimension to it, because obviously we're drawing districts, that's the point of it all. But to at least say, within this context, we can identify a group of people that are, seeing their own interests, maybe social, maybe cultural, maybe political, as being significant enough to at least have some consideration. Doesn't always mean that they are, obviously everybody's going to come to you and say, yeah, we're a group, we should have representation. I think this becomes the challenge sometimes as you're drawing maps. The law doesn't always direct you to do that, but you'd have to sometimes consider in the, mix of different groups that are making this assertion, all right, so how do you sort of make sense of it all? And sometimes, I'll just say, in large geographic spaces, you can have multiple groups saying, hey, we're in the same space and we're the people that need to have priority in how you draw this map. They aren't easy calls. The law doesn't necessarily tell you always what way to kind of work this out, but that's sort of where I was saying earlier, you aren't always going to be able to satisfy everybody 100%. But I think the challenge is to think through ways of maybe trying to get, enough to have people happy enough to, feel like, all right, I've got a fair shot in this district. That's sort of absent the point I was making about what the, laws like Section 2 requires you. But in thinking beyond that, if you're making choices among different groups, all of whom have a valid, reasonable claim about being a community of interest, that's where the hard work comes, I think, for you all to determine, well, how do you judge it? And that's one reason why coming early on in the process with priors and what your sort of commitments are about, well, these are features that we think we want to represent in a plan, that can be useful. I know there were people on Zoom just in case. I didn't know if we finished you out, but if you have a question, we're open to it.
Mr. Grant, do you have any questions for Dr. Creighton?
Hey guys, sorry I was connected to my AirPod. Thank you. No, at the moment I don't have any questions, but I wanted to thank you for sharing so much amazing information. I think we're going to take this into consideration. I'm going to take this into consideration for sure. I think that it's super important to highlight and make sure that we're in compliance, but making sure that everyone is going to have a fair shot. So again, thank you so much for your presentation and sharing this awesome information with us.
Thanks.
Yeah. Dr. Creighton, again, we're much appreciative of the time you've spent with us, and you've certainly educated us. Thank you.
Thank you so much. Appreciate it.
I did have one question. If members have follow-up questions, maybe through email, as they digest what your presentation, can we email them to you? And
Email is perfectly fine. Yeah,
Okay.
happy to do that.
great.
All right. Thank you, sir. Thank you all.
Yeah. If any of the commission members have questions, I can group them together and forward them and see if we can get some responses.
Sounds great.
Thank you.
Well,
Okay, next on the agenda is to update us on the redistricting application and the training session for next week.
So let me pass these out. We've been, commission members in general, we've been all emailing back and forth quite a bit to make sure that everyone has a good time slot. The GIS team and myself have been, I think we've got it almost worked out with just a couple of small tweaks. We know John and Ed, it seems like you guys want to do your training together, and that afternoon slot works. I just want to make sure, John and Ed, is that works? Okay. Michelle, she specifically requested a time, so we've put her in that slot. Same goes for Lisa and Cordell. So that really just leaves Eric. We kind of had a few different slots for you, and Al, who's not here, but I mean, I think he seemed flexible in previous emails.
Yeah. For me, Adam, whatever works for everybody else's schedule, I'm close enough that I can make myself available. The only time next week I would not be available is the Thursday morning slot.
Do you have a preference on whether you'd like to do an individual session or be paired up with someone?
No, I don't care.
Okay. I will reach out to Al, and because I think he might have wanted to do an individual session, but I'll confirm, and that should finalize it, I think.
Okay.
And I sent this same schedule to Michelle and Cordell. So I think, and you guys can correct me if I'm wrong, but I think we've got theirs finalized. Yeah. So just for anyone listening who's not seeing the schedule in person, we're going to be doing individual or two-member teams for the training. It's going to be basically most of next week. And I've also, just so you guys know, I'm also put in the dates that the GIS team and myself are going to be training ourselves, so that we can train you. That's pretty much it.
Okay.
I do have, want to bring something up. March 25th, we have a 6 p.m. Commission meeting, meeting number 6. Adam, do we? Okay, let's try this again. Here we go. Oh, for March 27th, we have the 6 p.m. Commission meeting. Adam, do we don't have any guests, correct?
That's correct. Yeah.
25th, correct, yeah.
To be quite honest, the main thing I had, at this point, since, that whole week is going to be training, the main thing I had on my mind as an agenda item was having everyone bring a laptop and make sure they can log in. But I don't know if that's a very useful, point. Now, that being said, if the group wants to meet and kind of review, the trainings that you've done, we could do that. Or if you'd rather just cancel that one because that's the week of training, we can, that works as well.
That's why I'm bringing it up to the commission. I'm just like everyone's thought on this, because we're going to be going through the training that week. And if we don't have a speaker present, I guess I'm just trying to figure out the reasoning for the meeting.
Yeah.
We had scheduled that one when we thought the training was going to be, this week. Yeah.
Yeah, and for that meeting, we'd only have 2 commission members that got exposure that same day. And, I think it would behoove us, because it's more important for this training, and we get it, be able to download it and get up to speed on that, and then get back together as a group after we all had our hands on it for a while. So I don't really see why we need to have that meeting.
Cordell and Michelle, I'd like you to weigh in on whether the meeting on the 25th is necessary or not.
This is Michelle. I concur. I don't see the necessity.
Same. This is Cordell. I also agree. With the training, with everyone trying to become and familiarize themselves with the program, I think the next week's meeting could be postponed.
I tend to agree. So I think we've heard from all the members that are at the meeting and all agree that we should not hold the meeting next Tuesday.
Okay, we will we'll scratch that from the schedule. That means your next meeting will be Thursday, April 3rd.
Mm-hmm. Right.
Okay.
Mr. Chairman and members, one other thing I just wanted to bring up is, and no determinations, you don't even really have to discuss, but so you're going to have a meeting, you're going to get trained next week. Hopefully, you can hit the ground running. I know it's not easy, but you'll hopefully get the training next week, and then we have the meeting on April the 3rd, which is the Thursday following, and then you have a meeting scheduled for April the 9th, which is the following Wednesday after that. And our hope is to publish a tentative draft map by Friday the 11th in anticipation of the public hearing that is virtual only on April 16, which is a Wednesday. So you've got April 3rd, Thursday, April 9, Wednesday for meetings. Hopefully we can publish a draft map by April 11, Friday, and then wrap around the following week, April 16th, a virtual public hearing. That's still our goal. But we understand also, or I guess I'm just throwing it out there, and I'm not trying to make it delayed at all, but I think it will really depend on your abilities to synthesize the map drawing and actually start doing it. So I think just something to keep in the back of your minds that's our current schedule, but it's obviously dependent on the commission members and whatever assistance you need from us, getting some maps together.
Mm-hmm. And let me in that regard ask another question of all the members in attendance tonight. Would any of you have a problem if we actually held 2 meetings on the week of April 7th? We can't obviously hold it on the 7th because there's a legislative session that day, but we could hold a second meeting that week, either on the 8th or the 10th, if push came to shove. And would that create a problem for anyone?
Yeah, for me, I have a commitment on the 10th, so I'd prefer the 8th if we needed to do it.
Well, I guess the biggest thing, how long would it take for, to get the information together to make, for the map, once we give it to you? Do you need a time frame? How long?
Well, once there's an agreement on a draft map, I mean, the benefit of this software is it's pretty much instantaneous.
Just want to make
we
sure.
can print off several reports, and there's very little drafting from our end once you guys agree on an actual configuration.
Okay.
So for that week of April, I have a commitment on the 10th that would prevent me from possibly doing 2 meetings for the week of April 7th.
Okay. Cordell, how about April 8th? Are you free that day?
Yes, the 8th works.
Okay. And I'm not saying we'll hold that meeting on the 8th, but I'd like to have it as a perspective matter, depending on how easily we adapt to the map making. Michelle, your feelings?
I have a standing appointment on Tuesdays from 7 until 8:30, so the 8th is not doable for me.
Okay. Okay, thank you.
Eric, I think we're going to know a lot more by Thursday, the April 3rd meeting. Whenever we come back in, everybody's thoughts on how things are going with the maps, if there's any difficulties, and I think we shouldn't make any decisions until we've figured that out. I mean, we'll know that information at that time. So
That's fine. That's fine. Thank you all. Let's see. Does the staff want to say any more about the public hearings?
think we have, I think, postponed the two that we had scheduled for in person, the one at the Perry Hall Library in the beginning of April, and then the one on, I think it was April 14th, so in Randallstown Community Center. So those are currently not being held. We're still looking at, potential other dates, probably later in April and into May.
Okay, thank you.
Thank you. But that's it. Thank you.
All right, there's one other matter I'd like to bring before the commission tonight. We received an email from Mr. Hinton asking if he could make a presentation to the group. And I'd like to officially on the record get our feelings on that confirmed so we can respond back to Mr. Hinton.
Eric, I did read his, the email, and I think anything in that nature, anybody wants to bring any information forward, it should be done in the public hearings.
Okay.
Once we start that, I mean, we're going to start a precedent. We're going to have everybody under the sun coming in here
Right.
wanting to do a presentation, and we just won't get anything done.
And I would also add that Mr. Hinton actually testified at our first public hearing. So he's already had one opportunity, but he was asking for a second. Anyone else have any feelings in that regard?
No, I agree with what Ed and you said, and if anybody wants to testify the second, third time, we're going to have public hearings set up for that. And, we have a task to do and a task to get done in a short timeline, and I just think that would exasperate the whole process. So that's why we have public hearings for people to sign up either virtually or in person.
Any further thoughts from either Michelle or Cordell?
Yes, I'm in agreement with that train of thought. I think that the public meeting should be the place for the testimonials or the additional information sharing.
So I think Mr. Hinton's approach is, he wants his voice to be heard, and I too agree that our goal is to ensure that we do this and we complete this task in a timely manner. However, I don't want to necessarily approach this in a way it feels like, I guess, he can't be heard. Yes, he can discuss at a public hearing, but I think that we have a lot of passionate people within our constituents in the county, and so yes, we have ways by communication through email. Maybe we have to be creative in ways of allowing these constituents and people who care about their community to share their thoughts in a more with more of a presentation. But I do agree that we all need to do this in a more efficient way. So I have to move along with the group.
Okay, thank you. And so all in favor of setting a general policy that we will not accept individual presentations outside of the public hearing process?
Are you motioning that?
Yes.
I'll second that.
Voice vote?
Aye.
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 Okay. And just for the record, I will respond back to Mr. Hinton, and I will encourage him to submit some written testimony as well as he can come to either or both of the public meetings in the future. Actually, we'll have three with a second virtual, so he'll be able to to instruct us as to what points he wants to make in that manner. Okay, thank you, Commission.
So, Mr. Chairman, I have a question? I do agree with some of Cordell's statement regarding constituents being compassionate and allowing their voices to be heard. But the one thing that I would like to put out for the commission to give consideration to is, even if there's allowance for the presentation of further testimony or other insight, I think that it has to be provided in a way that it's concise and it doesn't just go on and on and on, or if it's presented via slides, there are multiple slides. I think that if there are bullet points, it's very clear, it's very concise, it's easy to follow. I would like some consideration to be given to that, because just reading and spending a lot of time going through emails, if that's what this is going to turn into, we just need to get to the crux of what the point and or the consideration is that those who will send this information want to be considered. That's my only request for consideration. Thank you.
Thank you, Dr. Davis.
Hi, this is also Cordell, if I may, Chairman.
Yes, go ahead.
I also thank you, Michelle. I also agree with you. And with these creative approaches, giving consideration to our constituents, I too wanted to be concise and make sure that, it gets to the point that the intention and the purpose that it's presented with, and so we're presented with that, and so that we can take that information. So whether it be video, PowerPoints, slides, etc.
Okay, thank you. Okay, are there any final matters for tonight's meeting? Hearing none, I'll accept a motion to adjourn.
Motion to adjourn.
I second.
All in favor? Aye.
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 Hi.
Aye.
Thank you all. Good night.
Good night. Thank you, everyone.